Hello, this is Matt on the Moon Lambo channel. Here's a brand new headline from the Daily Hodl. Crypto legal expert says XRP settlement between SEC and Ripple could be imminent. And they're talking about none other than attorney Jeremy Hogan. And Mr. Hogan shares a number of thoughts. And I'll show you where it stemmed from, too. It's from a discussion within the XRP community. But Attorney Hogan also goes on to talk about, I guess it's fair to say, his expectations and perhaps general curiosity regarding the final phases of the legal process in this case. Because remember, summary judgment, that's when the final determination comes in from Judge Torres to determine exactly how this is all going to shake out. So as long, if there is no settlement, that's how this thing ends, in summary judgment. And there are summary judgment briefs leading up to that, which would be some of the final arguments in the case, which will, of course, undoubtedly heavily impact what the actual summary judgment is. So we're talking about the very end phases of the case, and we are approaching that. So even if we don't see full adjudication until next year, in terms of a potentially imminent settlement, yes, it's true that Attorney Hogan indicated you could see something sooner than later, but I'm going to share with you his exact words and what the timeline is, because it doesn't necessarily mean that it's going to happen tomorrow. And I'll share some additional thoughts from my own on that. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And by the way, I've actually got a perspective and comment from 3 attorneys within the XRP community. So it's not just Attorney Hogan, but also Attorney John Deaton and Attorney Bill, who's been talking a lot. And I've covered a lot of what he has had to say on my channel. I just find him to be rather insightful. And I love getting the perspective from various attorneys within the XRP community. So where did all of this stem from? Well, let's set the table. There's this short thread from an XRP community member, and the name's funny. I like it. It's A Dingo Ate My XRP, which I'm assuming is a play on A Dingo Ate My Baby from Seinfeld. You may be familiar. And so I found this short thread to be insightful and well articulated. So I want to share it with you because this is what Attorney Jeremy Hogan ended up sharing, and he expanded upon it. So here's what was said by XRP community member on Twitter named A Dingo Ate My XRP. Early in the Ripple v. SEC case, NetBurn decided internal memos were relevant. Memos about how the SEC chose to treat Bitcoin, ETH, and XRP, and what factors drove their thinking. Now, why? Scienter, in part. If SEC didn't know XRP was a security, neither could Brad and Chris. Yeah, exactly. So it's possible. That's one of the bigger arguments. That's one of the biggest annoyances, frankly. In the SEC says, no, it doesn't matter, Scienter, schminder, right? It's about what Brad and Chris did. That's more so what the SEC has to say, but it's always been grinding my gears, because if the SEC didn't even know, how is that remotely fair? How could Brad or Chris, even if they strongly believe something, how could they be held to such a standard if the SEC isn't being held to that standard? And then A Dingo Ate My XRP continues. But things go deeper than the individual defendants here. I believe NetBurn expected the SEC to argue that ETH and XRP differed in fundamental ways. That's why the docs would be especially relevant, since, of course, they stated ETH was not a security. But the Hinman affidavit turned the story on its head. Just imagine a judge asking for docs that help the SEC explain why they treated ETH differently, only to get the response, we didn't. The argument she assumed would be a key theory of the case, gone. Yeah, so let's pause and note. And that is an interesting concept, right? Because as Ripple themselves have argued, based on the Bill Hinman Ethereum Free Pass speech on June 14th, 2018, there certainly were market participants that thought, oh, well, based on this, if you plug XRP into this framework, which is what the SEC is effectively pushing here, of course XRP isn't a security. In fact, it hits the Billy Boy Hinman Ethereum Free Pass speech criteria even better than ETH does, because there was no XRP ICO, right? So it fits it even better, right? And then A Dingo Ate My XRP continues. NetBurn knew the assets would have to be compared. In the absence of clear regulation, she believed the Hinman speech would be their guiding light, and then they just pretended it didn't happen. I think it speaks to both the arrogance of the SEC and their severe short-sightedness in this case. The judge handed them an opportunity to use prior decision-making to beef up their flimsy argument, but instead they just replied, "No thanks." Good thread, right? It's well articulated, straight to the point. It's a short thread, but really just makes the point that it's the guy's seeking to make here. So, missed opportunity for the SEC, perhaps. They're not arguing that they're different, but in hindsight, in a way, I also think, well, yeah, of course they didn't, because if they start arguing about the differences, then they're, well, a couple things happen there. They'd be providing clarity in theory, but it's, still it's through regulation by enforcement, but they don't want to talk about the differences necessarily from one crypto compared to another. They will in a vacuum speak about individual cryptocurrencies they're attacking, but they're not attacking ETH. Why would they want to compare it? Because they can hold their feet to the fire. So in that sense, it's like, well, yeah, this is what we now come to expect, but it illustrates the absurdity of all of this, right? And so attorney Jeremy Hogan retweeted that thread from Adingo ate my XRP and wrote the following: "Great analysis by Adingo ate my XRP." I love that name. It's good. He says, "One thing I'm interested to see soon in the summary judgment briefings is to what extent Ripple makes the comparison between XRP and ETH." End quote. Right. And so undoubtedly there's going to be something in there. Just it's more so a question of to what degree. I'd be very shocked if they didn't make any sort of comparison. They've certainly talked about it in the past, so why wouldn't it be in the summary judgment briefings? That'd be kind of weird. So it's going to be in there, right? Now, attorney Bill from the XRP community jumped in and wrote the following: "What do you think they will do, Jeremy, with the common enterprise prong of Howey? My concern has been SEC would get away with not having to show it in the Library and Ripple's cases, and Library and Ripple would concede it too easily and focus only on third and fourth prongs of the test." So let's pause to note, again, the Howey test, it's 4-prong test. The prong having to do with common enterprise is the one that Kim Jong-Gensler has been conveniently pretending doesn't exist, despite the fact that there is legal precedent dating back to 1946, resulting in, as a result of the Supreme Court case, the Howey case. He says that it's not a 4-prong test. Literally on video, I've shared this before. Kim Jong-Gensler says that the Howey test is a 3-factor test. That's the way that he worded it, 3-factor test, and he doesn't talk about common enterprise, because if there's a common enterprise prong, that makes it much harder for the SEC to argue its cases successfully. Common enterprise? Well, how can you have a common enterprise if XRP is completely decentralized and Ripple doesn't have any special powers over it, and there's all sorts of developers building on top of the XRP ledger? Kind of destroys that prong, doesn't it? So better to just pretend it doesn't exist. Now, that's not the only thing to consider. Attorney Jeremy Hogan had the following to say in response to what Attorney Bill wrote there. Attorney Hogan said, "To me, the case law on common enterprise has diluted the prong so much as to make it a weak place for defendants to hang their hats. I'd be surprised if Ripple uses too many precious pages on arguing it. There is so much to argue in that case in very few pages." End quote. See, and that is concerning, admittedly. And that's why I'm so thankful that we have perspective from the attorneys within the XRP community, because that's perspective that the rest of us who are not attorneys would not just come to on our own. In terms of understanding the case law that's led up to this point and the impact that it actually has, he's saying that particular prong of the Howey test, there's been so many cases since 1946, if I'm hearing him correctly here. There's been so many cases, precedent's been set in such a way that it's actually weakened that particular prong. That, if I'm understanding him, that's what it looks like he's saying to me. That's concerning. That is concerning. I know it doesn't mean he didn't say that, it doesn't matter, but it's still, if it's weakened, right? Now here's what attorney John Deaton had to say. He jumped in and responded to that comment from attorney Hogan. He said the following: "I'm curious about early years versus present day, direct sales versus secondary market sales, non-investment versus investment. As for common enterprise, they need to focus that if XRP itself is a security, she would be deciding first case in 76 years with zero privity between buyer and seller." End quote. Yeah, and that really would be something. There's been nothing's been decided even close to this, which is why I would love to know, and this is not me questioning other than in a friendly way. I take Jeremy Hogan at his word, of course, just to be super duper clear. But I'm wondering if there are simple things that he could point to that has to do with the dilution, in which ways it impacts the case. because according to Attorney Deaton, in response to that, it would be the first case in 76 years with zero privity between buyer and seller, which is an interesting fact. And in fact, consider, I was going to share this for later, but this is probably a better time to just plug this in, and then I'll get right back to that, because I think it flows perfectly. There's this tweet from November 21st of last year from attorney John Deaton. And think about this one. He wrote, "I have objective empirical evidence that almost 60% of XRP holders acquired XRP for the first time completely unaware of Ripple. Under Howey, it's difficult to establish purchasers of XRP were relying on the promises and inducements of a promoter or company they're oblivious to." End quote. So think about it. It's fine. I'm not a lawyer. All right? I don't have a legal background. I'm just sitting here saying, as someone who I do my best to just approach life in a logical, reasonable perspective approach. How is it logical? Just forget about what's likely in the court of law. How is it logical to think that there is a common enterprise when upwards of 60% of first-time purchasers of XRP don't even know Ripple exists? What common enterprise? What in the ever loving hell is the SEC talking about? Now, Attorney Jeremy Hogan responded to Attorney John Deaton's thread where he's talking about, hey, 76 years, this would be the first case, zero privity between buyer and seller. And Attorney Hogan says, "I certainly hope they frame it that way. Unfortunately, you have cases like Kick Interactive where the judge lumped all of the various offerings into one amorphous sale and avoided some of those questions altogether." So, that is concerning. And I don't know exactly what the implications of that would be, but it just seemed to me like that judge just perhaps wanted to kick the can down the road. Now, in terms of that being some sort of legally binding approach, my understanding is the answer is no at this point. So, Judge Torres could find something that we are very happy to see she finds. It's just not explicitly clear. And then there was this. Attorney John Deaton also retweeted the thread from a dingo ate my XRP and said, 100%. The case was filed in a rush as Clayton, Hinman, Berger, and others were walking out the door for good. The lawsuit was a weapon, pure and simple. And because it wasn't filed for valid reasons, SEC lawyers have been all over the place making inconsistent arguments from day one. Yeah, true words have never been spoken, that's for damn sure. And then there was this. Somebody named Yo Soy Krut wrote, "Hi, Jeremy. About a year ago, you stated that around September 13th would be the most likely settlement date. Do you still believe it could happen? And, of course, thank you for your very educational work regarding this case." And Attorney Hogan did write back, and he said, "Most likely settlement timeframe is from now until end of November because the cards will be on the table." Yeah, exactly. So it doesn't mean like literally this is going to happen tomorrow, or that within that time frame that he cited, which was this morning, he said this, mind you, so from today through, November, it doesn't mean that in that whole time period that today or tomorrow would be the most likely time for this to happen. My personal opinion is that the most likely time period will be after Judge Torres rules that the SEC loses on attorney-client privilege and deliberative process privilege, which Judge Neprin already decided on both of those. But, the SEC appealed to Judge Torres, so once we hear back on that, assuming Judge Torres does back Judge Neprin on those topics, and I suspect she will, at that point, the SEC is going to be like, oh crap, well, we really do have to hand over these documents, or we can settle and not hand them over. The Billy Bohemian and the Theory of Free Pass Speech related documents, because there's got to be something in there that's super damning to their case, or else they wouldn't be fighting this hard. It could be completely exculpatory. It could show that they don't know what XRP is, or they didn't back then right before the speech in 2018. Well, they're not going to want that out. So that's why I'm saying, in terms of when's it most likely, at some point after that happens. So I don't think literally, today or tomorrow, and I'll set the timer from whenever that ruling comes down, if it comes down. But other than that, I'd say, nah, probably not before that. But we are at the point where we're about to get that in all likelihood. So that still is exciting. It could happen soon. But even once that ruling comes down, that's when the discussions would really begin between the SEC and Ripple, right? So it doesn't mean that it would happen, the week after that, or 2 weeks after that, or 3 or 4 weeks after that necessarily. And that's why I think Attorney John Deaton, when he spoke on this, he's like, well, if it's going to happen, probably within 90 days from that being the starting point. And then somebody else named MD Hesk wrote to Mr. Hogan and says, doesn't the thread completely miss the, referencing a Dingo 8, my XRP's thread, which I shared with you, said, doesn't the thread completely miss the fact that nothing in the Hinman speech is precedent? And here's a quote. This speech expresses the author's views and does not necessarily reflect those of the commission, the commissioners, or other members of the staff, end quote. ZERP needs a much better defense, and with ZERP being XRP, it's the slang term for XRP. I think most of you know that, but it's more so used on XRP chat. I don't see many using it that too frequently these days, which is why I thought I just mentioned that for anybody that's new may not have heard that. A ZERP is XRP. Anyway, Attorney Hogan did respond to that and wrote, the SEC has backed off that now and admitted the speech was in fact guidance from Hinman's division, although not the entire commission. Also relevant regardless in RE, the fair notice defense. Yeah, exactly. It's not just Hinman's opinion. They've explicitly stated it's part of the SEC, but not the SEC itself, right? And it was guidance. The SEC also ceded that point. Well, how about that? They've been so all over the place. So let me know what you think, but there's tons of reason to be optimistic for the future. I'm still anticipating this is going to be favorable for XRP holders ultimately, even if Ripple has to pay a fine itself for specific sales of XRP in the early days, something like that. But the idea of XRP never being traded in the United States ever again is so absurd. It's hard to believe that's the most probable outcome, although I admit horrible things can happen. That's not where I think this thing is going. I think in all likelihood we're going to see a settlement at some point, but even if full adjudication, probably in favor of Ripple. I'm biased, but I do believe that. I genuinely believe that. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.